I got a ride there. What it's all about. But went, and it was sort of a status and a bit of a cheerleading session because they've already turned in the signatures.
Yeah, to
They're doing the validation or whatever steps they take, and they put the analysis out for bid, for proposal. Or they put a proposal out for bid. And so they went through, and I've been to some of these other meetings. This one was a little more organized from a presentation standpoint. And I think what they were just trying to do was explain it to a different audience. So they had it at Mountain Luxury's office up in Eden, which hadn't been a site for one of these. It's probably a little bit smaller audience, but a different audience I saw before. And I think they were just trying to cheerlead it a little bit and get a little info out there in the lenses.
Okay. Interesting that you want to put the study in bid because the LG's office that hires.
Correct.
We're in the process of verifying.
Correct. So they said, and I've heard this before, that typically they choose Zion's Bank for the analysis. And but it was said again that Zion's Bank would probably bid up this.
But it won't require a vote still. That's not because it's not West.
So it requires another signature gather. And then.
So this one, so the feasibility study has several. And then if it passes certain markers from the ability as the city, then we can go to petition. And then that one you have to get a certain percentage of representation. We also have which will be properties are well, not adding that, but also whether you gotta get that company that's giving legal offer.
You're talking about the petition prior to
yeah, one that's current.
and then if that happens, then it goes to vote, then it's all the registered voters in the valley, is that right?
So for the petition to succeed, we still have the percentage requirement, 7%, 10% of the value, 10% ownership. But then you add on that.
A lot of Did it already happen once? It's happened. I've heard it's happened.
And then failed to a point. I guess what happened.
From what I've heard, it's because they basically can't prove that it's not gonna be a huge tax increase.
Cities live and thrive off tax. And so the question is, did they identify a sufficient area as capturing percent?
It's on that. I mean, Snow Basin and Powder Mountain probably help a lot. Okay.
Want to chat about it?
Yeah. What's that?
Want to chat about a B&B?
Yeah, let's do it.
I'll be presenting that tonight. I'll just run through the slides. Jeff Barber? Yes. My name is Felix Lleverino. Pleasure to meet you. Nice to meet you. And so, yeah, I'll just walk through some of the points that are related to the bed and breakfast, also commission permit review and design review. And we'll move on from there. If you have any questions on that bed and breakfast dwelling, which is just one bedroom that we can do make available. Bedroom, one extra one parking spot for that one bedroom. Good work.
This was built in 1968, right?
Yeah.
So as far as the question, I don't know. ADA, like, how does that work? Like when you have to do an Airbnb or not an Airbnb, a bed and breakfast, right? How does that work from I know they wouldn't be required to update the building because it's in the state it is, but how does that whole thing come into play?
We just rely on the building code and submit things and.
But the building code as of 1968, no, today, right?
I would assume that's the case, but we just put it over in there. So-
And if they sign off, then.
Yeah. Most likely they're going to review it for whenever they put the building code and then. We don't really get involved too much. Cool. If you want me to find out more.
No, I
information,
don't, I'm good. I just,
Do they require sprinklers in for something like that? Sometimes they have required them to retrofit, depending on how much area.
That's a good question, because the final review requires things that related to safety. Basically, your smoke and seal detectors in the room, in all the rooms. And then basically they limited total occupancy, which is quite high, but that's not a concern because their occupancy is.
I've just done a number of these CUPs for applicants, right? I've been the applicant a number of times and wondering how you guys look at it.
Most of the time, I've never seen them come in and say, you've got to retrofit the whole building for the sprinkler system. But they very well could, especially when you get into remote areas. They address the parking, right?
Yeah, so what they've shown on their site plan is the space, one additional space, and it's inside there. Well off of the road, outside of the front yard setback area and actually the banana trees, the line of trees on the boundary of that property.
Shows a red car right here in this photo, that's the space.
I believe so, yes, that's probably why I put that in there in the maps. I think that would require on it. That most recent photo we have in there, it's been smoothed up quite a bit, nice paint job. Some landscaping, some work done.
So is this based on agritourism? Is that how we're doing the CUP on agritourism? Is that?
Well, it would actually be just be CUP bed and breakfast dwelling, and so it's written in the Forest Valley Food Zone Code.
Okay. It's the AVs that don't have B&B, but that you can get there for agritourism.
You guys have any questions on this one? Fairly straightforward. Is Courtney here? Well,
Just stepped out.
do you guys have any questions on the rules of order? And it's totally okay if we have two separate rules of order, one for Western Weaver and one for the Ogden Battery. Right now, they're the same. So if you guys want, different standards in your rules of order, don't feel like you have to go with what Western Weaver has. But that was
After a meeting yesterday, Cortland and I went through some things that I noticed in here, and he suggested just bring one to the meeting tomorrow. Okay, he said, yeah, I can see that, I can see that.
So
These been noticed 14 days ago?
definitely. We sent this out prior to our regular meeting. And I checked on that because I was on the, so,
Well, there were some grammatical things, just typo kind of stuff, but we could make things that needed.
yeah, definitely.
He agreed some of these things are kind of ambiguous. So further definition suggested, and I thought, well, maybe we could discuss those things. We could even move to adopt them subject to changes.
Yeah. Yeah, and if it's more just wordsmithing, things like that, if you guys feel comfortable with, worth having legal work that out with, you know, and it's not totally pinned down, we can do that. But if you don't feel comfortable, then just move it on to the next one. It's not that big of an issue that, you know, push it around. Portland mentioned, and I understand, that his office didn't go through this thoroughly reading it, and yeah, this hasn't been went through thoroughly for years. We use a fair amount of it, but a lot of it we just have never gotten into. So it's good that we are. I understand. I mean, it's something that everybody just, oh yeah, let's have that again. But nobody looks at it. But some guys look at it. Oh, any sense? That's awesome. So it wouldn't be a total cleanup, but it would probably be a.
Review it. You had, I had asked about having the Valley, and you had mentioned there was some procedural things or things, and I know in here it references any place, it says it can be other places. Are there other matters other than this to determine, to deal with being able to have meetings up there?
No, this is
it.
that's what determines it. And most of the time, just because of financial situations and things like that, we're always gonna have the meetings here. Because it doesn't require a lot of money to get our staff up there and to get things running, and it doesn't work great when we get up there. We don't have the great Zoom ability. We probably won't have our meetings as much online if we have them up there. They'll probably be more in person. That's what I probably recommend. So, and when I was mentioning the hijacking thing, it wasn't a huge issue, but it was a little bit of a concern because we had represented to the public that it was going to be an open house type format. And then a few of the folks up there went to the front desk of the library and got microphones and just came in and tried to make it this formal meeting. And it was never advertised or put out towards that. And the librarian just gave them the microphones. And it's like, wait a second. And so I didn't want to be rude to them or anything like that. So I just accommodated and says, yeah, you know, we'll do this. And Janet Wampler came in and she's like, what's going on? This is not like this. And I'm like, I understand, but you know, trying to keep some of our Gem Valley folks, you know, that.
So this has written though, assuming other matters are handled, this allows it to be held up there.
Yeah.
So,
Yeah. Okay. Yeah. And most of the time we've had it either at the library or at Eden Valley. They have an indoor area there. So usually we try to get one up there once a year.
I do think it would be wise to probably budget more if there's, I'd say to your point.
I think going to that corporation meeting last week, it was clear that there's, I don't want to say misconception, but there's a perception that probably could be more easily dealt with if meetings were easier for people to get to. Yeah. And as I also mentioned, information could be found in some ways and people would not think one thing when reality is very different.
Yeah.
And, so I just think it'd be nice to have meetings up there. Yeah. And there are probably better locations. One in particular, I think, belongs to Summit. It's a well-connected, good-sized building that they a lot of community events to have many times. So not about
Oh,
the one
Arbor.
Arbor.
Yeah.
Big, it's nice.
Oh,
There's
yeah.
Plenty of chairs.
Arbor's
It's
big.
connected.
We could solve the IT thing too.
Oh, definitely. IT could be.
Arbor's where the liquor stores. I'm sure you know that.
There is a liquor store.
Yeah, it's the alcohol spirit, so like when you come around the corner going up the Powder, the last building on the left, before you.
That's the.
So Bowers right next to the golf clubhouse.
Ours is the restaurant, the Arbor is.
What's
It's
the
just-
name of the Brandy Hammond, right? Owns that.
No, Brandon owns the one down here.
Oh,
So you know where the clubhouse is for the golf course, right?
yeah.
Right next to that's the Bowers. And then if you're on hole 18, that's Arbor that backs that.
We historically tried to keep areas that are business neutral.
Yeah,
That's why we've had it now.
everybody loves something, it's fine.
But I can. You know, it might be helpful when we have these meetings up there, if you throw the first component to the little training for us. Courtland. Part of our training tonight is the scope of the discretion of planning commission to do stuff. Like you've given us on conditional use permits. Unless there's some compelling reason not to do it, you have. Because I think folks may have a misconception. This is a group of kings, county commission, group of kings, and do whatever they want. Lean on them, they'll do what we. But that's not the case. So if that were a little training for us, maybe the community would train, just short, 5 to 10 minutes. Yeah, to set the meeting off on the right track. So I guess I want to go into this meeting place, been brought up a bunch, you talked about that. What are the hurdles that keep us from doing that? I'm reading the rule of order, they're the same. Shouldn't be an issue. What keeps us from having it there? I know it can be tough. Staffing issue, because right now we have to deal with 2 planning commissions already. And then I have to deal with overtime, and I have to deal with comp time out, and trying to get packets out, and I have to work on travel time, and dealing with that. That's the biggest
What do you think that delta is in cost?
It's not as much cost as it is trying to manage time and getting reports out when I need them here in the office, doing stuff, getting things done, as opposed to getting them up there and getting everything all set up.
In my thought, I think you could have less on the agenda and have them up there and probably have a better impact, less corporation talk, right? You could see more of a whole. In my, just thinking out loud, right? I think the community would feel more involved if they were.
Oh,
And we can do less on the agenda. If it's time your staff needs, it's gonna be solved that way.
So is it, I guess, and don't take this the wrong way, basically, it may be very good for the residents to have these up there. If nothing else, just for during the public hearing, right? And that might be an easy way to start getting, I say easy, start getting it better, making it better. People feel more comfortable. And so if it's a matter of resources, or what is it, maybe, I don't know if the rest of the language, maybe we ask the commissioners to start to kind of really look heavy at what we could do to get that done. You know what I mean? Yeah, definitely. And I'd be willing to chat more with the commissioners on that too, and that's something. But it would be good to have a come from you guys too, with the commissioners. I don't know how we would do that, but I don't know if the rest of you would support that, but maybe in a public hearing setting, at least, I don't know how you would judge it, but at least in public hearings that we do it up there. I know, at least I remember the one we did up there. I wasn't part of it, it was up at the school. Remember that? So, I know that might be too much, but. Yeah, some of our big ticket items we try to get up there, like we had the graphic that was behind the junior high, we had it at the school, the junior high. And then when we did the water study, we had that up at the elementary school, and so. And there's big ticket items and that
I think the folks behind the incorporation, which I personally think will fail driving out of meetings, but I think they're using the fact that the meetings are here as leverage to say that Ogden Valley is disenfranchised from the process. And I think that's not true, but I think that could easily swap that around.
well, if you want to kind of go down to this franchise, we've totally came in franchising, bringing them on board with Zoom. We never had that 2 years ago, and now people can sit in their living rooms and participate right in the meetings. So, you know, to make that argument, I think is totally not correct.
I think you're being impacted by another public. So you have that period. Swim for the work session. And so now they've gone back to about Zoom for all of the work sessions. So that could help.
Which I was so glad that they are going back to that, because it does look, you know, it's like, well, you have that capability, why don't you and take advantage?
I think that is,
Whether
is there like a newsletter or something you can sign up for to potentially let you know when meetings are? Because I personally, I don't follow when, I know when they are, but I don't personally get on and go to them.
Yeah,
I barely remember when these are. So part of me is like, if there was something saying, hey, county commission work session tonight, it's like an email, like you could sign up for alerts. Is that something we could do?
I'll send you the link to the Utah State. So I can't remember what it's called.
the Utah State notice site.
We may, it may already be there.
Jen Fulmer's on that, and anyone who wants to, we get them right on that link. And so that's why when Jan sends out those notices, is that she's on our link and she's aware of that. And so anyone can get on that, and it's just super easy, and there's a lot of people that do. And so they're
It's just
aware
part of
of
the
it.
problem.
And then on our website, we have all the commission meetings, we have all of planning meetings, we have a calendar of events that's happening on all those things. Some of the reason why we haven't used the Valley News as much as we typically have is because sometimes things aren't represented how we give it to them. And so-
And that's why I was thinking, if you give them a document that's not intended to be used other than as that verbatim document, maybe that would be helpful. Where they either publish what you give them.
They'll publish whatever they want.
Yeah, well,
That's the way I
for
was-
sure.
Case in
But
point.
there's other outlets that probably would publish a summary on a regular basis. verbatim.
And Jen's been pretty good when we've given her information. She doesn't change it, you know, what we give her, and so we do that. You know, when there's hot ticket items.
the latest thing that she's been upset about, she reached out to me and she wanted to complain about the fact that we don't give more than 24 hours notice for public meetings. And you know, if it's possible, we will, but just administratively, so that
We had pizza that was supposed to be delivered, I'm not sure where that.
Yeah.
Anyway, the work session item, if you guys want to, you can, I can hear.
Yeah, we'll do that. So let's go and we'll get started. We'll talk more about this because I don't know if everyone agrees, maybe we should talk more about it.
We're coming back.
Yeah.
You bring my bag. I don't give you mine. Yeah. Really, just like this one. Thank you. Yeah.
Comment, and I know that some of the items are not on the agenda, but if there's some things you'd like to say, there is some time if you'd like to say something. Just be aware. So we're gonna go ahead and get started with the Pledge of Allegiance. Okay. So we have Commissioners Torman, Johnson, Burton, and Barber are in attendance with the other are excused. Just so everyone's aware, online and in person, there has been a change to the agenda that went out about 24 hours ago. A couple of the public hearing items were postponed or tabled. Some of the items that were found is that we needed more information, more details before it could come. And there's also a meeting for an incorporation that's been held, and we wanted to make sure that there was plenty of time or plenty of that the community had the ability to come attend both meetings if they wanted to, or that wasn't impeding their ability to come to these public hearing items. And so with some of the concerns, those items were removed. And then there was some documents that didn't get published on some of the other items that needed to be there. So those items have been removed, and they will coming back at when things at a later date that will be noticed and everyone will be made aware. So with that, if there is someone who did want to make a comment, there is a public comment that we'll be getting to. So be aware that you can still be heard. The minutes have been distributed for October 4th, 2022, October 25th, 2022, November 29th, 2022, and December 6th, 2022. Not hearing any adjustments to the minutes.
I do have two.
We do, okay.
I don't know how, but I was in two places at once, according to the minutes. I was excused and then there on the 4th and the 6th. I was present for both of those, but it says I was excused, so.
We have some corrections to be made on the 4th and the 6th to show that Commissioner Johnson was in attendance. Those are noted. Are there any other adjustments that need to be made to the note that are noted to the minutes? Not hearing any, they're approved as adjusted. And we will now go into a training by the Chief Civil Deputy Attorney, Chris Crockett.
Thank you very much. Planning Director Grover is passing out a few documents that we're going to refer to in this training. So if I'm successful in this training, I will make you all regret your decision to engage in public service. So we'll see how it goes. This is a training that my staff and we decided to ask for permission to put together because there was a recurring theme that was coming up and we were getting questions.
And so we wanted to take the opportunity to address a particular matter and also to help you meet your requirements that you have under the code to get so many education hours each year. I believe it's 4. And this would count towards that. So tonight we are going to be talking about conflicts of interest and when it's appropriate to recuse yourself from participation in a particular matter. There's a few things that we're gonna lay some background, kind of more of the boring stuff, and then we'll get into some more in-depth discussion, because you'll find later on as we go on, the answer is not always clear as to whether or not a conflict of interest exists and whether or not someone should recuse themselves from participation. And then after that, we're going to have a discussion about the rules of order, which you considered in a previous meeting, and then Cortland is going to assist with that. So if you will look at the first document that I provided, which is the County Officers and Employees Disclosure Act Code Acknowledgement, that is one that we're going to be going over. This is a section of code. It is applicable to county employees, elected officials, and then any appointed officers of the county, which also includes county boards and committees. So the Planning Commission is subject to this act. And so we're going to go over the requirements of that. Many of these things you're going to already be familiar with. And so I apologize if I'm stating things that you're already aware of, but we do require our employees to acknowledge and this form each year, and we're probably going to start making this a reoccurring training that we have with all of our boards. The first couple parts is one: if you receive protected information, you protected from disclosure, you're not allowed to disclose that. Obviously, you can't use your position to secure special privileges. And then one that we often get asked about is you're prohibited from knowingly receiving, accepting, taking, seeking, soliciting, directly or indirectly, they cover everything. Any gift or loan for oneself, another, if the gift or loan tends to influence, and that's the key language, tends to influence him or her in the discharge of one's official duties. There's some limited exceptions to that. A non-pecuniary gift of less than $50, an award that's publicly presented, and then a couple of other things that we don't see too often. But the ones that I wanted to focus on are these things dealing with conflicts of interest. And we have, there's sections of the code that deal with assisting others in transactions with the county. I'm not going to be focusing on that. Interest in business entity regulated by the county, that might be something, that is something we'll discuss tonight. Interest in business entity doing business with the county. And then the big one that we want to focus on is investment creating a conflict of interest. Now, what is the primary purpose of this act is not to force a recusal in participation in any manner. What it is to ensure that any interests are disclosed so that they're out in the open. The legislature does this all the time. Before participating, they have to disclose any business interests that they have. And there's going to be particular language under the statute to indicate whether or not the statute is triggered. For example, the interest in a business entity regulated by the county. Everyone subject to the act who is an officer, director, agent, or employee, or the owner of a 10% or greater interest in any business regulated by the county must disclose that position, the value of the interest, and you do that annually by making a sworn statement filed with the county commission. The one that we want to focus in particular tonight is this one: investment creating a conflict of interest. States any personal interest of or investment by an individual who is subject to the act, which creates a potential, that's a key word there, a potential or actual conflict between the person's interest and his or her public duties, must disclose in a sworn statement to the county commission and also in an open meeting to any county body of which he or she is a member, the nature and value of the interest or investment if it exceeds $2,000. So two ways to that you have to disclose. One is each year we will ask the planning commission to review this form. And if they determine that there is any conflict of interest, to fill this out and return it to either June or Rick Rover. The second part is if, say, something comes up that you weren't aware of at the beginning of the year, and you feel like this might be subject to the act and you need to disclose, you'll do that orally in a meeting. You'll disclose it on the record, and then we would recommend that you go and fill one of these out and turn it in. So, any questions regarding that? Yes, please. One of the same questions the Western Weaver Planning Commission asked. I mean, we can all find some way that we're regulated by the county and business licenses or some interaction that we have. The way that I explained it to Western Weaver was, if you have a business interest and it's regulated by the county and you anticipate that it's going to come before the planning commission, or it's going to be a part of the discussions, I would err on the side of caution and go ahead and disclose. I always say just when in doubt, disclose. So there won't be any harm in doing that. But obviously things that really, if you have a business interest that's out in Western Weaver, or they really have no ties to land use or any subject matter that you're going to be dealing with, I don't really see that it's necessary to disclose. Cortland, do you have any different thoughts or any additional comments on that?
Just the fact that you pay real estate taxes on a piece of property that you may rent out is not enough to be regulated by the county.
I wouldn't think that it'd be subject to it. But if you feel that it might be something that the public would like to know about, and it meets that criteria of what is listed, if you have that 10% or greater ownership interest, then it's not going to hurt anything to disclose. But in that scenario, I personally don't think you would need to disclose. Thank you. Did you have a question?
No, it just came back to that. Like if you look at land and then we invest in, say you're 100% owner on a piece of property, real property, right? And you look at it and you're like, okay, how do you just, right? Because if it comes up, right? So all of a sudden, let's say use form based, for example, you owned a piece of ground that got the street maps, the regulating plan put on top of it. At that point, should we declare? Like, I don't personally, but that's the point of like, okay, now there could be a real value of something that just was created. Does that question make sense? Like, yes, he paid real estate tax on a piece of property, but now it became before a street regulating plan, which now allowed for a monetary gain, right? I know I'm going down a rabbit hole. I just would rather not end up in an orange jumpsuit at the same time.
Well, good. No, and I appreciate the seriousness that you take it. I mean, one, we all pay taxes, and so in one way we're affected. But as we're going to talk about a little bit later, the real decision to declare, it's a personal decision. We can give your opinion whether you should or not, but nobody can really force you to. So if you feel that it'd be something that the public would be interested in knowing, even if it doesn't meet this criteria, there's nothing that prohibits you from going ahead and disclosing.
And then it says nature and value of the interest. What can you define?
I would say, obviously the name of the business, what your position is, what your ownership interest is, things of that nature.
But you wouldn't need to necessarily specify, I get 50,000 for 20% interest. That's not what you're saying in this.
It really doesn't give any boundaries of what you have to go ahead to disclose with that. And so it could be two different people having the same issue could disclose it completely different. Sorry, that doesn't feel like a very satisfactory answer. But there's no guidance under the statute.
Yeah, the state law just says disclose the position held and the precise nature and value of the officer's interest. It doesn't define those.
Yeah, because we've all disclosed things before up here, right? But never to that degree when there's been a conflict. So it's just trying to understand the.
Could disclose.
They use the word
I
precise.
say precise. I mean, and what we're talking about here is the disclosure made in a sworn statement filed with the county legislative body. So that would be the purpose of this form right here.
Is the word precise your word or the state code?
That is from state code.
Okay.
State code says disclose the position held and the precise nature and value of the officer's interest.
I'm not aware of any action taken against anybody for not being precise as to the issue of how precise it is. The biggest issue is that if you disclose that you disclose. I think that's where the protection comes. And I like that you don't want to be in an orange jumpsuit. It is important to remind people that failure to do this is under the statute a Class A misdemeanor. And the statute mandates that the individual immediately be dismissed from employment or removed from office. Again, I've never actually seen that enforced or have an example, but that is what the penalty under that particular code is. Any other questions? So we wanted to give you a little background as to why we felt this was necessary to bring before you. So you're all familiar with the rezone issue with the Nordic Valley rezone. There was an issue that came before the county commission regarding disclosures under that particular provision that we just discussed. We looked at it in consultation with, internally with our attorneys, with other agencies, the state auditor's office. We have thoroughly gone through this act, and the biggest thing that we want to emphasize is disclosure. Now, the issue of recusal is something completely different. There is nothing in this act that would require or force a recusal. So we wanted to make that. So we're going to now delve into something a little bit different, and we're going to engage in a discussion of, what happens if you don't recuse? What are the consequences of that? Because here it's black and white. And we're going to have to, if you take this next form that I have, which has some definitions on the back, and then it has a section of state code regarding district court review of land use decisions. Let's talk about a couple of things. One, let me ask you, as a planning commission, what would you say your primary function and role is as a planning commission? Planning commissions were originally created to assist with legislative matters, creating ordinances, drafting the general plan, making recommendations to the county commission as far as future laws. Those are legislative acts. You have in that capacity, you have a tremendous amount of discretion. That one, Cortland, he may have his own opinion on this. But it's my opinion after looking at this, under legislative matters, disclosure of a potential conflict is the critical part. I can think of very, very few times that I personally would recommend recusing oneself from a legislative matter, as long as you have adhered to disclosure requirements. And that's because under legislative matters, we want public input. We allow ex parte communications. You look down at the legislature, individuals who serve in that position, that's not their full-time job. There's different interests that are down there, but they all are required to disclose, not recuse. Any questions about that? Where it gets interesting and more tricky is under administrative matters, because then you have a particular applicant who is coming in and asking a question. They're putting forth a proposal, and that is where you're acting in a different capacity. You're not acting as a planning commission, you're acting as a land use authority to make a decision on land use applications, and where you'll render a land use decision or administrative. And when people come and they have a particular application, they have due process rights, and they have to have a fair shake. You have to present, they're allowed to present their issue. And again, this is all stuff that I know you're all familiar with. They will present their land use application, and under the law, you are required to assess whether or not that meets the requirements of the code. If it does, the law requires that you approve that application. Very, very important. And those, we want to make sure that we limit ex parte communications. We want to make sure that we stick to creating a record. We don't allow public clamor to come in. We want to make sure that we create a sound, solid, and expansive record. This isn't your full-time job. You all have different jobs, different interests. The important thing for you to keep in mind is that when you're sitting in the capacity, the chair that you are as a planning commissioner, you have fiduciary responsibilities where you have to ensure that you adhere and respect the due process rights of those who are coming before you. And so sometimes you have to be able to set aside, personal judgments, or you have to be as objective as you possibly can in assessing those administrative applications. And if you look at these definitions on the back, I've got a couple of them at the top: arbitrary and capricious, and then substantial evidence. And then on the other side, you're going to see a section related to district court review. And so we'll go over these definitions. Arbitrary and capricious, according to Black's Law Dictionary, is a willful and unreasonable action without consideration or in disregard of facts or law. Substantial evidence means evidence that is beyond a scintilla and a reasonable mind would accept as adequate to support a conclusion. So those terms, let's now go to what the court is going to actually assess when they have an appeal of a land use application. So first of all, the court's going to presume that the land use decision is correct. Presume that the land use regulation properly enacted under the authority of this chapter is valid. And we will actually, the legislative matters, the only thing the court's going to look at is determine only whether the land use regulation is expressly preempted by or is enacted contrary to state or federal law and is reasonably debatable that the land use regulation is consistent with this chapter. There's so much more flexibility with legislative decision actions. The administrative one. So a court shall presume that a final land use decision of a land use authority or an appeal authority is valid unless the land use decision is arbitrary and capricious or illegal. So as you're sitting there and you have say you've disclosed and there's an interest there, and you're trying to determine whether or not you should continue participating in the matter and recuse yourself. Again, this is a decision that you are going to have to make individually. Of whether you can objectively act on the application. If you feel like you can't, and you allow your personal judgments to come in, that is where the risk is. You talk about protecting yourself. The risk is that you possibly will render that decision invalid, and that it will be found to be arbitrary and capricious because it's not based off objective. every year the legislature brings up the issue of penalizing government entities in land use cases. And you all are in an absolutely tough position because no matter what, you are guaranteed to make somebody mad. You're going to have one side that's hooray, you did the right thing, and other side who is just going to think it's an absolutely terrible decision. So you're put in a very, very tough predicament. But if you are able to, if you do feel like you have a conflict of interest and you feel like you cannot give the person adhere to their due process rights, please recuse yourself. Allow the other members to take up the issue. And I actually have a ton of admiration for individuals who can say, you know what, I'm just too invested in this. I can't separate it out from my personal feelings. There is absolutely no shame in that. I think it shows a good form of character and judgment to do something like that. If, however, you feel like you can set that aside, what I would focus on is make sure you have substantial evidence. So you're going to create a thorough and robust record. You're going to make sure that your motions are based on the information and the evidence that was presented before you properly, and you're going to reference that in your motion. If you do that, then it's going to withstand appeal. That's how you protect yourself, is create an adequate. So, any questions on that before we move to the rules of order? I am probably taking long.
So on the Black's Law Dictionary definition of arbitrary and capricious, who decides if something's unreasonable? What's the standard for that?
If it gets ultimately up to a court, it's a judge. But we can predict whether it's going to be arbitrary or capricious if you stick to the record, if you cite to evidence that was presented in the planning report or material that was presented in the application. If you tie it to that record, you're going to be protecting yourself from it being declared arbitrary or capricious. You have to go way out there in order for it to be arbitrary or capricious. And don't forget, the court is going to presume that you made the correct decision.
And is there any application of arbitrary and capricious to a legislative item?
No, the court again will presume that it's correct, but they will only disturb your decision on that if it's not reasonably debatable. And the courts will very, very rarely interfere in that area because they recognize that they are not elected or appointed officials to perform executive functions. And so they're not going to say our opinion is better than yours. They're going to defer to the ones who were elected and appointed to be in those positions. I can't even think of an instance where a land use decision was overturned. Not a land use decision, a land use regulation. Can you think of one? That's why the recusal and the conflict is so important under the administrative. The disclosure is important under both. Pay particular attention to it. If there are no more questions, Cortland had some information he wanted to present to you with regards to the rules of order.
Any further questions before we move into the rules of order? No? Okay. A while back, as you know, we looked at a couple of these provisions that were in the rules of order and proposed an update to you. You had the chance to talk about those at your last meeting, and we then, at your direction, prepared a couple of options for you to consider tonight. So disclosure in accordance with that he or she cannot do that impartially, then the member shall refrain from participation in the discussion and voting of that matter. So that is the way we adjusted or amended that first part that we're going to talk about tonight. The other option retained a little more, I guess, detail. So this is the document that was titled Option 2, showing addition. We kept that paragraph the same. And again, these are just proposals for you to consider here in light of what Chris just talked about. We added discussion of what the state code requires, some of the types of disclosure that are required. We point out that that's a summary, not guaranteed to be complete, and members should refer to the state code for applicable disclosure requirements. And we mentioned that it doesn't require recusal. The state code only requires disclosure. And then we did, in the second option that we drafted, say if a planning commission member believes that another member has an actual or potential conflict of interest, the member may raise that concern. The other member shall be given an opportunity to respond. The chair may allow other members to ask questions or provide input, but ultimately it is the sole responsibility of each member to determine whether or not he or she is able to fairly and impartially discuss and or vote on each matter, and to determine whether or not to refrain from discussion and or voting. Now, everything I just said there is not prohibited by option 1. It's just spelled out more explicitly in option 2. There was some discussion last time of even going back more to, or sticking with, I should say, what the current rules say, which, you know, is your prerogative. We just feel like it's not necessary. We, meaning the attorney's office, feel like it isn't necessary to have that procedural stuff where a member can trigger an election, not an election, a vote, wrong word there, trigger a vote on whether somebody else has to leave, because really that goes against what the state statute requires. And it really goes against what the intent of this would be, which is to allow or even require each member to exercise judgment and discretion and to be honest and open and comply with the disclosure requirements, and then determine whether or not to vote on particular applications that come before you.
And if I can offer up an example, in a larger body like this, the likelihood that you'll come to a correct result, I think it's increased. But if you have a smaller public entity with say three members, you can see how that can become incredibly political to force someone who's been elected or appointed out. And it might not be tied to a actual conflict of interest, but something very different. And so it really does come down to the statute, or it goes to the individual to make that determination.
So option A1 is each person decides, yeah, I think I can go forward with impartial judgment. If we adopted option 2, any member of the commission can say, wait a minute, I think you might have a conflict of interest. There's discussion, but it's still up to the individual member. I can be impartial.
Correct.
That's the end of discussion.
But option 1 doesn't prohibit that either. It's just written explicitly in option 2. I personally don't see a need for it to be written explicitly. I mean, if you as a commission just have the rule that says a member with conflict of interest shall disclose it and decide whether or not to recuse himself or herself, there's nothing that says another commissioner couldn't raise that. And, the member would have the chance to decide still. The outcome, I believe, is the same with both of these.
So we just went through an issue. I'm concerned about disclosure. What's needed. I guess the heartburn I have is it seems like we're trying to make it easier to do the thing that I was most concerned about. I don't think any of us are doing any of us have the problem, that we aren't disclosing or we aren't accusing. I don't know what kind of message it sends to say, trust us, we got this, when that was the big concern with what brought all of this about. It's the concern that we just have to trust them, So I guess my heartburn is why? Like what's wrong with keeping it a little bit more strict as it was making it open? That's why it seems odd.
So why are we recommending departing from that? Part of it, I think, is to avoid the impression
But doesn't that increase the impression if we're removing all that? He can make that determination. I don't know.
Okay, to avoid the impression that anything more than disclosure is legally required would be part of the reason. The way the current rules are right now, they go above and beyond state law. They allow, as Chris just mentioned, the possibility of some, I guess I would call it undue pressure for a member who can fairly and impartially participate in an item to remove himself or herself from the discussion when that person's perspective might be fair, impartial, and valuable. But if the other members of the commission, or if the rules of order say, we should talk about this, then maybe that, takes a valuable perspective away that doesn't really need to be taken away.
That's a good point that, you might miss out on that. It is a 7-member board.
And if there's full disclosure in accordance with the law, so that disclosure happens, that person has done everything that's legally required to.
I guess the hard time that is that we're going from where we're setting a higher bar for ourselves and setting a higher expectation to a lower bar. And I feel like it's being pushed. That's the heartburn I have.
That we're recommending it.
Yeah,
sure. We're recommending it because we feel like issues have come up where it caused a stir that was not something that actually involved any kind of legal violation or anything wrong. And people got up in arms over that when the person was not doing anything wrong.
But if this were to be enacted, those same concerns would still be there, is my concern. So if we were in that same scenario, current rules allow us to have something a little bit more strict. And in these rules, it's less. And so if we're trying to avoid something, it seems like we're trying to hide something more than we are trying. That's what it seems. State law might require. I guess what's our risk?
I think one of the risks that you're going to encounter is that it confuses and sends a message to the public that there are more additional requirements than are actually required by the law. I mean, we've looked at this, we've confirmed with the state auditor that this is the process. I mean, this is the standard that is governing all county employees, officials, appointed officials, elected officials. There's an enforcement mechanism under there with it's a Class A misdemeanor, removal from office, where if you don't, especially when you're distinguishing between legislative and administrative acts, legislative, setting up a process and forcing someone out to not participate in that item any longer, I think that goes against what the intent of that act is, and it hinders the role that person was put in there. An example that I discussed with Cortland a while ago was say that, we're all sitting here for for jury duty. And we're trying to set a fair and impartial jury. And I feel like I can do that. I feel like I can set aside any, preconceived notions and apply the facts to the case as the law is explained to me. But I have another individual come in and say, no, you actually don't have the ability to do that. Is that person really qualified to determine whether or not I personally have a conflict, and if I personally can engage in that discussion and adhere to my fiduciary responsibility?
I just want to go down that route just a little bit. I like hypotheticals; they work well for me. So let's say someone does vote you out in that case, right? Applicant is approved or denied. Either way, doesn't matter in this case. They go and file an appeal, and they said, now, however, if you're sitting in that seat, I think I likely, they voted yes and they got voted out. Could it overturn in a court of law? If you could show impartial and unbiased.
What the court is still going to look at the land, and you're referring to a land use decision in your hypothetical?
Yeah, one that would be over, like in the case that we said, hey, you're biased, we vote he or she out, and then they come back and they file for an appeal. Sure, anyone that could get overturned.
If the decision is supported by substantial evidence, the court's going to presume that it's a correct decision, and if there's substantial evidence on the record, the decision will be upheld. If you somehow ousted the one person who didn't have who shouldn't have been, and the rest of the members voted in an arbitrary and capricious manner, maybe that would.
So may I see if I understand his hypothetical or his question there? Are you asking, what if maybe it was a 3-3 vote, a 3-3 tie, and the members had voted out another member who could have cast the deciding vote?
So it happened here, but I this did happen where we did have a vote cast. The applicant said vote. None of us looked at these rules of right. We didn't know, we didn't have them in front of us, so we all had to vote. But that did create tie vote. It did create the applicant not getting what they wanted in that case. Could they file an appeal and go back? I don't know. I'm just asking, is that a good or?
Well, I agree with Chris that, if they filed an appeal, it would follow that standard that the statute lays out, which talks about the evidence. Is there substantial evidence to base it on? And so the findings that supported the motion that was made would ultimately be what the court relies on. And which, yeah, there are all kinds of interesting scenarios. I mean, what if Commissioner Torman has a conflict of interest on something and the Planning Commission as a whole votes on something? Maybe he votes in a way that is opposed to the outcome. In the end, that's going to have no bearing whatsoever on anything, because the rest of the Planning Commission voted a certain way. And if that decision that the Planning Commission made was based on substantial evidence and, it wasn't arbitrary or capricious, then that had absolutely no impact on anything.
Let's run a couple scenarios. We leave the rules in order with the conflict of interest as is. Disclosure is still required. In both scenarios, it's both disclosures required.
Correct.
Right? I guess the only difference is there's somewhat of a standard established, and there's a possibility get voted out in both of the scenarios. So when I look at a risk, the risk of having a problem in both these is that we may have with one scenario, we may be short a commission member or two. And that's it's a concern, because there might be a voice, but whether that voice should be heard is kind of really up to the person in the one scenario, just up to that person who may or may not actually have a problem. And in another scenario, we kind of get to vote on it. That's pretty open. And so the risk is we change the rules, we make it easier to hide a problem. Let's say you had a problem, you're trying to hide it. We're going to make it easier by doing
How is it easier to hide?
I guess hide. You could just say, I don't think it's a problem, but you know, if someone else had, you know, if someone really knew the full extent of it, or, you know, they don't have to because it's a personal judgment decision, right?
So it's easier to vote, whereas in the,
Disclosure, we got to vote. I don't think it's a problem. I don't think it's a problem. Okay, it was at least viewed versus I just decided that that it wasn't a problem. I didn't really have to disclose. Because I think that's what it says, right? You're supposed to disclose it, but you get to make that decision. Right? It's more open in the new language. And is that correct?
well, the new language requires disclosure in accordance with state law.
The old language is a little bit more strict in what disclosure is required.
Well, the old language, the current language says a planning member with a conflict of interest in a matter before the commission shall state that such a conflict of interest exists and withdraw from participation in the public in the meeting. And if they feel that they may have a conflict of interest, they shall explain the possible conflict to the commission, which shall then vote.
So I guess what I'm trying to get at is the risk of changing it to making it easier, really just like the public can view this negatively versus like what's our big loss.
That's absolutely true. And if the commission votes to or decides to keep the rules the same, that is an option.
Another consideration to keep in mind is in talking with our insurance company over this issue, there was concerns raised that we might be in violation of the Open and Public Meetings Act by requiring the commissioner to actually leave the chamber if a conflict is voted out. At the same, and I understand, I respect your argument as far as, you know, we're just setting a higher standard. But I hope that you can see and acknowledge that there's a possibility that it could be used for improper purposes too, to remove somebody who really, they are the only ones in the position to say whether or not they have the ability to act in a fair and impartial manner. It can become incredibly political.
We had that happen too.
When this first came up, I think one of my comments was to the effect that if we focus the attention of the meeting on, we're going to decide if you get to vote or if you have to leave the room, it takes the focus off the applicant and the application before us. And it may give additional, it's the red herring. Well, they didn't remove somebody or he didn't leave or something like that. And it really didn't matter. If this were a king in here or a 3-member commission, I appreciate that observation. It's a little bit different. Here we have 7 members. And as I understand our purpose, it's get all the information we can on the table. Let's have an open discussion about what the applicant is asking us to do. And if we have disclosed possible conflicts of interest, then we know where this commissioner is coming from. He may have a conflict of interest, and we can, in our coming up with our decision on the applicant's request, we can take that into account. We can take into account the comments of the potential conflict of interest commissioner. Well, he may be coming from a different place. He might have a conflict of interest, but we can focus our attention on the law and what the applicant is coming to us for. He's entitled to a fair hearing of his application from impartial people. Well, nobody's really impartial, so we declare our potential conflicts, and then we work together to go through all the comments, all the facts we can get, and come to the best determination we can with regard to his application. And we're not sidetracked by, well, somebody should have left the room. Kind of that.
So being new here and maybe not having all the history, I think I tend to agree with what I just heard, and that the law is the law. The state law is the state law, and the public's going to think what they're going to think. And as you just said, the discussion will ensue, and with 7 members, one individual isn't going to make that much of a difference, but there will be, the public can think what they want to think.
But the state law is the state law.
Thank you very much. And Commissioner, would you remind me of your last name? I'm so sorry.
Burton.
Commissioner Burton, I really like the way you stated that. If we I mean, and the law anticipates that some of these might get through these conflicts. And that is why the court has a standard up there of where they're going to review. And if that conflict gets in there and it contaminates the decision so much, the court is not going to let that decision stand. They're going to overturn it for being arbitrary and capricious. So what you can focus on doing is making sure that you have a really good record that's based off evidence that's within the law. And that is the protection, is because if it's appealed, a court will not disturb that decision.
I think it's important that we have these discussions, considering the could go for a long time and not get changed. So I don't want to make changes like.
And in all, I appreciate the process of how this issue came about, because it really forced us to think and get in there and make sure that, we provide training and we look at this and we're doing it right, because we all want to take our responsibilities and our roles very seriously, and we want to apply the law correctly. And please remember that option 1 or option 2, there's nothing that prohibits you from discussing this, to raising the issue. The thing that would change or that we would modify is who has the ability to recuse, and at what time is it appropriate to do so. Any other questions, or were there other questions about the other changes under the rules of order? There are a few things added about ex parte communications, electronic communications.
Court, I don't know if this is the right time, but Cortland and I had a discussion yesterday about some small wording items in the proposed rules of order. And he suggested that I just bring them up in this meeting and see if we can't see how the commission feels about these little word changes. And as history, and Cortland, I don't want to put words in your mouth, but these rules have been around a long time. They've been approved every year. And as a practical matter, nobody ever pulls them out and looks at them very much. So this has been an opportunity to go through them more thoroughly, although a thorough review, I understand, has not been made.
But I would agree. We have not done any kind of a complete revision to try to review and rewrite the whole rules of order, in the sense of looking at all the provisions and, line by line saying, does this make sense? I mean, that's not something we've necessarily done in my time here.
Yeah. One question I had was on ex parte contacts, and this is the red line version, page 3, top of the page. And I think the intent here is on administrative items, we're not supposed to have ex parte contacts. If somebody makes a contact with us, we're supposed to get that information to the secretary so it can be part of the public record. So the word information is used here. Is it, Cortland, what's included with information? Is it somebody coming up to me in the Valley Market and say, that thing stinks? Okay, so do I have to call the secretary and say, somebody told me that thing stinks? Well, is it oral? Is it brief? Is it pertinent information? Maybe there could be an adjective that makes this more workable and yet gets into the public record things that should be in there. So I think I suggested maybe pertinent information or some adjective that restricts somebody stepping out of bounds if he didn't report some brief oral irrelevant comment.
Correct, and we might say written information received by a planning commissioner about an administrative item must be forwarded to the secretary of the commission if the information has not already been provided to the planning staff. We do already earlier in the paragraph say planning commission members shall reveal any ex parte contacts at the commencement of the public meeting. So there is already that requirement, and you do ask for that at the beginning of the public meeting or the discussion of that item. Has there been any ex parte communication? Maybe we limit this sentence to say written and take out the telephone part. Does that make sense?
As a practical matter, that seems to be less of a tripwire that, oh, I broke the rules.
We can make that change if you'd like.
Okay. The next item was in paragraph 7, gifts and favors. We decided that a public officer is, yes, a planning commissioner. Let's see. There were just some, we were talking about our English teachers in high school, or my English teacher. And there's some grammar problems here that, since these rules reflect the competence of the planning commission, they ought to be proper grammar. I'm referring to, we're talking about no public officer, singular, or loan for themselves, which is a plural. It's just pronoun agreement. It's picky stuff, but I just suggest that these things be cleaned up so that they're more understandable. I've always been told that precision in language is very important in the law.
We can do that.
It's part of the, I guess that's part of the heartburn I have with this, is we really only made one change. Like you mentioned it, we didn't review all of it. We just looked at one portion. One portion happens to be, in my opinion, it feels weird that we're only looking at one portion. We're just,
Well,
it feels weird.
there have been lots of changes based on our discussion last time, a lot of red line changes. Right.
Because I was looking.
Have you looked at the red line version?
I was looking. I guess that's
Okay.
This is a document that is brought to the planning commission every year for review. And each year they'll take, if I'm correct, you take a vote to approve them.
So being asked to do the same on a big change of disclosure. This is the same.
And I would say that's completely discretionary. If you want to take a look at the entire document and go through a more thorough review, you're welcome to. You are also welcome to piecemeal it out. This was a significant enough of an issue that we wanted to bring it to your attention quickly. If you wanted to address that issue now, you can do so, and then do another review at another meeting of the rules of order, or you could table this and take time to look at the entire document. It really is up to you how you like it.
See, for example, in paragraph 10, no, this is paragraph 10 of the red line version. This is the
B10, right?
Yeah.
On B10.
Well, I'm looked on. And yeah, D10. Conduct of members of the commission, paragraph 10, communication between planning members during a meeting. I think Cortland suggested this is added language. I think commission members shall refrain from engaging in communication with other commission members during a public meeting. That's new. Yeah. And so my question to Cortland was, well, I know what the goal is that all deliberation should be in public. But how careful do we have to be during a break? And so we talked about, well, maybe during let's have a definition here or more precise language about during a public meeting. Is that during a break? Is that when, we want everything to be in the open, but this may be a little broad. So during the active part of a public meeting or something.
Right, and let me explain a little bit of background to this. And speaking with Chris about it earlier. There is a section of state code that says nothing in this chapter, this is the Open and Public Meetings Act, says nothing in this chapter shall be construed to restrict a member of a public body from transmitting an electronic message to the other members of the public body at a time when the public body is not convened in an open meeting. So what that is saying is the Open and Public Meetings Act does not prevent Commissioner Barber from sending an email or a text message to Commissioner Burton, for instance, at a time when the public body is not convened in an open meeting. Kind of the reverse or inverse or opposite of that implied in that statement is that you should not be sending electronic messages to each other during a public meeting. So we think if we limited this by adding the word electronic, that would address that statute. So commission members shall refrain from engaging in electronic communication with other commission members during a public meeting when such communication is not part of the official record of the meeting. We think that would, at least I think that would meet the purpose of what the statute is trying to say.
Yeah, well, it's not convened in the public meeting. Yeah, we can have a communication while we're not convened in the public meeting because we're taking a break and
Yeah,
we're just talking about the ball game or something.
any oral communication this way would be not prohibited. It would be applying to electronic communication. The idea is presumably the legislature meant to say you can text and email outside the public meeting, but even though they didn't explicitly say it, the implication is they don't want you texting each other during the public meeting.
Okay, so that's helpful. Thank you for having this discussion. My last comment is on F1. Making of motions. I think this is some old language that I just noticed that, and what I asked Cortland was, when somebody makes a motion as written, it says you can't have any discussion on the motion until it has been seconded and repeated by the chair. But from my experience with the commission here, somebody makes a motion and then there's discussion about would you accept a friendly amendment and things like that. So
We can certainly take out that sentence if you would like it removed.
but then the old language is a commissioner may support the motion, adding compatible findings. And what does that mean? It was a little arbitrary. So we thought, okay, you can discuss it without adding compatible findings, you can just have a discussion. So Cortland, I think, suggested we could remove adding compatible findings, which really simplifies understanding what this is meaning.
Yeah, we could delete that whole sentence too, if you would like, which makes sense to me.
I mean, this is your world, but it seems like it picks it up, though. I think it says a second shall be required, period. Other members of the commission may support the motion by adding compatible findings. It's almost saying a second's required, but others may also, I don't know if there's a timing in that. I agree with you. It might be,
It's confusing.
it's confusing.
You can support it and say, yeah, I like that idea.
Yeah.
Without the requirement that you add another finding to be.
And there are other sections here that talk about friendly amendments and other amendments that could address that need to add additional findings.
So with the rules of order, we can either table it, we can either motion to approve or Guess I need to call for a motion. Is that correct? These rules of order.
There should be some sort of action on this, yes.
Our recommendation would be that at some point in the near future, address the issue that we discussed tonight. But how you go about that, whether you table it and you want to have a full review of next meeting, go through this, make all of the comments that you want, the changes that you want to have happen, piecemeal it out. Any ways we just, our recommendation is that we do address that one particular issue.
When you say address it, the current language does not address it. But there's a concern that current language addresses it, but the concern is that someone could be silenced. Is that what you're, just if I'm trying to kind of get the picture of why you would want to make that change, right? Like is that the reason? From a simplistic standpoint, it's the only thing I can think of why you would want to make that change.
Not for simplicity, it's to accurately reflect what the law states, to have consistency across all county boards with regards to this. And it provides a mechanism for us to adhere with state statute and also to preserve our decisions, to make sure that they're to adhere to those responsibilities, not have it be arbitrary, capricious, substantial evidence. We feel that model that we are recommending is the appropriate model to accomplish that.
That were recommended.
Two options. One is it doesn't make a reference as to a planning commissioner's ability to raise the issue of a conflict of interest on behalf of another member. It does not prohibit you. And I don't think there's anything wrong with actually engaging in those discussions. We all want to make sure that we are objectively addressing this. The second option specifically states that you do have the ability to raise those discussions, but under both options, the decision of whether or not to recuse falls upon an individual planning commission.
Well, so both these, 1 and 2 that you've given us are both options that we'd asked for before.
Correct.
And one of them was to give examples, which is what's given. That, and then it adds that paragraph that you're talking about. I guess both of these are, what's the big difference between what's there now and this? What's the only difference? Is got to be the dismissal, because this says dismissal is not required. That says dismissal is required. Is that right?
The current rules of order do allow the planning commission to take a vote to decide whether another commissioner should withdraw from participation in voting in a matter. So the way it currently reads, you could all vote and actually have to vote if somebody raises a potential conflict that somebody else has. And then that decision determines whether or not that person participates in the voting on a question.
I can tell you when we presented this issue to Western Weber last week, they voted with option 1. In my opinion, either option. It doesn't matter. I talked with Rick Grover as to whether having 2 sets of rules would cause an administrative problem. No.
I just don't. In option 2, it just gives a lot of text and ultimately gets to the same thing.
Correct.
So you're just creating a document that's longer for the sake of.
But
I get the clarity there. Don't get me wrong. It's just you're getting to the same. Bottom line is declare it, recusals on that person.
Correct. It is same result. One, I mean, I can see the benefits of both personally. Option 2, if you have a new planning commission member come in and it's like 9 months before you review the rules of order, you give them the rules of order. This lets them know that that's an appropriate thing to do. And if you want to raise that issue, I can see the benefits of option 1. So
We. Call for a motion. I'd like to make a motion. I move that the planning commission adopt as its rules of order.
Oh,
The-
I'm sorry, this is very rude of me to interrupt. But there is one thing that we maybe ought to mention that Western Weaver did, if there's any interest in trying to be the same as what Western Weaver recommended. There was a change made by them, or a decision, I guess I should say, way at the back of the rules of order, paragraph K. There was a question about whether you want to continue to get 14 days written notice of any proposal to amend the rules. And I wasn't at that meeting because I don't advise Western Weaver, but my understanding is they wanted to continue to get 14 days notice, right? Okay, so they wanted to leave paragraph K as is. There was a question out in the comment there about should we keep that requirement? So just wanted to make it clear that they wanted to keep the 14-day written notice requirement. So I interrupted you rudely. I apologize for that.
That wasn't rude. That was helpful. Thank you. Okay, so I move that the planning commission adopt as is rules of order. The rules of order sent out to us on, I think it's February 7th. The red line version, well, it's the clean version. Okay, including the red line changes. Before adding the additional language in the third thing that was sent out. Okay, because we had the changes sent out on February 7th were sent to us in the form that there was the first PDF file was a red line version. The second was a clean copy of the first file, which was red line. And the third was some additional comments that the attorney's office suggested adding, which is option 2.
At the request of the planning commission.
At the
yes.
request. Okay. So my motion is that we adopt the clean version, the second document sent out on the 7th of February with the following amendments. That would be on paragraph B5, where it talks about information regarding administrative items are prohibited. Information received by a planning commissioner, that we insert the word before information, written, the word written. That paragraph 7 be amended to correct the incorrect grammar for the purpose of making these regulations and rules more precise. That paragraph 10 be amended, communication between planning members during a meeting be amended to match the state code language with regard to electronic communication during a public hearing. And finally, paragraph F1 be amended to remove the requirement of adding compatible findings. That those 3 words be deleted. Also, that on the option 2 language, that the examples that begins with, as of January 2023, the following are examples of situations that require various types of disclosure under chapter 1716A of the Utah Code, that those be added to our rules of order as information that might be helpful for us to better understand what disclosures are to be made, are required to be made, and that the addition end with the sentence, as of January 2023, the state code does not require recusal in any of these situations. It only requires disclosure. That the language about a member may raise a concern about a other commission member having a possible conflict not be included in our rules of order, as it's not prohibited by the language that I've proposed we adopt. And finally, that the attorney's office consider over the next year more thoroughly reading through these to find anything else that would make them more understandable, more clear.
May I ask one clarifying question?
Yes.
On paragraph F1, you also mentioned previously the sentence that says discussion of the motion should not take place until it has been seconded and the chair has stated the motion and called for discussion. And did you intend for that to remain as is?
I forgot to talk about that. Okay, F1. I'd also add that we not that F1A be amended to not prohibit discussion of a motion, brief discussion of a motion before a second is made. I would say brief clarifying discussion may be held prior to a second.
Do I have a second on the motion?
I'll second.
Any discussion on the motion? All in favor?
Aye.
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 Aye. Aye. The motion for rules of order adoption.
Thank you very much.
All right.
Chair. That Senate, just for clarification here, I want to make sure I get it right. That sentence about discussion of a motion, should it just say, did you say brief discussion of a motion may occur before a second? Is that what you said?
Yeah.
Yes.
Thank you.
Okay, we're going to move on to administrative item 4.1, consideration and or action on a conditional use permit for the Mcleod Bed and Breakfast Dwelling. Would you mind explaining the decision?
This is an administrative decision, and you're going to be looking at the land use and making sure it meets the code. As such, if it meets the code, you're obligated to approve this item. You can take public comment, but here again, if you do take public comment, you can't consider any type of public clamor. It's meeting the code, or if it's not meeting the code. And Mr. Lleverino is going to be presenting.
Thank you.
Good evening, commissioners. What we have before you this evening is a request for a conditional use permit to operate a bed and breakfast. The location of this is, as you can see on the aerial image, it's right next to the Nordic Valley Ski Resort, and it's just up the road on 2700 North. The bed and breakfast dwelling will offer one bedroom for guests. They'll put a cap at 4 guests maximum per stay. One additional parking space is required that per the Forest Valley 3 zone code that specifically regulates the bed and breakfast dwelling. The standards for the bed and breakfast are in the staff report, and I'll walk through those really quickly to show that these have been satisfied. 2 parking spaces shall be provided for the host family plus 1 space for each guest room. The proprietor or owner shall occupy the property. Meals shall only be served to overnight guests. Signs are limited to a nameplate identification sign, not exceeding 2 square feet in area per dwelling, not more than 2 guests sleeping rooms per dwelling. Allowed only in existing dwellings with no exterior additions or changes in residential character. A business license shall be obtained. And here we have the conditional use permit review. That's part of the Forest Valley 3 zone. We, as planning staff, part of our review, we get an opportunity to look at conformity with conditional use permit requirements. We also give that opportunity to other review agencies like engineering and fire. And in this case, what we've done is we've gathered some comments from the fire department related to safety for persons and property. Fire department recommend that smoke detectors and CO2 detectors are installed in the rental space, and the total occupancy load shall be kept at 10 or less. The standards related to infrastructure and amenities. So there are several B&B dwellings in the neighborhood, and staff is unaware of any negative effects that could result by this use. Standards related to an environment. The proposed use is not anticipated to negatively affect the surrounding environment. The qualities and characteristics of the surrounding area, being that it is quite close to a resort, it is a good location for this type of use. And going on to the design review standards, in this case, what we're looking at is the fact that this is open up to public for public to come and visit. Some of the things we look at that might arise by way of like nuisance factors. In this case, what we're looking at is traffic safety. In order to mitigate any safety concerns, the bed and breakfast will keep the parking on the property. The visitor vehicle will be parked on the side property and outside of the front yard setback. And considering outdoor advertising, there's no advertising that the owner is intended for this use. Landscaping, this is a well-established home with landscaping that well meets that minimum standard. Building and site layout, the building has actually been brought up to a really good state of repair, and it's definitely been improved for this type of use. And easements or drainages or other engineering questions. Engineering has reviewed this project and does not have any concerns with this. Any prior concept plans or associated rezoning agreement, there are none for this property. Here's an image of the bed and breakfast that will be used for the guests. You have the garage, some garage space for two parking spaces in the garage, and then on the main level you have the family room, and on the upper level you have the bedroom. Staff recommends approval based on the condition that the owner obtain a business license. And the findings that are included with the report are that this is allowed by conditional use in the Forest Valley 3 zone. And that possible nuisance factors are mitigated. And that concludes my presentation. We have Kelly Mcleod with us as well. Any questions you have for her or me, I'd be happy to answer those.
All right, thanks, Felix. I'll entertain a motion.
I'll move to approve the file number CUP 2023-03, consideration and or action on conditional use permit for the Mcleod Bed and Breakfast Dwelling. Address is 2653 Viking Drive, Eden, Utah. My motion is to approve the conditional use permit per the staff recommendations and the findings in the staff report.
Do I have a second?
I'll second that.
All in favor?
Aye.
Aye.
Aye. Thank you. Okay, we'll move to the public comment for items not on the agenda. So we have a hand online. There's some in attendance. Please keep your comments to about 2 minutes. State your name and where you're from. We can go ahead and start online with Jan Fulmer.
Okay, can you folks hear me all right?
Yes.
Okay, good, thank you. First of all, the decision that you just made for the bed and breakfast, yes, it is certainly allowed in that zone. But what was interesting was a recommendation was made by, I think, the fire department to have smoke detectors and CO2 detectors. I hope someone thinks about maybe making that a requirement, even not only for B&Bs, but also for short-term rentals. And I'll tell you why. Our furnace turned off. We have a home, it's only 15 years old, but our furnace detects when the input or the exhaust vents are plugged. There is so much snow on the roof, that is exactly what happened. So for the safety and welfare of visitors, of renters, I think that might be a good thing to have checked out, to make sure things like that are in place. But what I really wanted to mention was, is there any way a deadline can be set to get all the information for the Ogden Valley Planning Commission meetings, maybe at least 4 or 5 days before your meeting starts? I heard my name mentioned before the meeting got started, and I do send out emails to the Ogden Valley distribution list I maintain, which is about 1,800 people now. And I try not to keep sending out, oh, it's been updated, it's been updated. I try not to keep sending out all these emails. And I usually wait until the Friday before the meeting. And first of all, thank you for changing the critical items that would have been on the agenda, which were the rezones about Eden Park, because I just got a text message from my husband who's at the incorporation meeting, and it's standing room only. So I hope I got the notice out that the sensitive subjects weren't going to be talked out at this meeting. But to get those detailed PDF packets, some of them are 100, 120 pages. I know you folks don't have a lot of time to look at that stuff and understand it and figure out what's going on, but neither does the public. So is there any way you might be able to influence getting that information ahead of time, a few more days at least, and cutting the line for the deadline for submitting it? It would be very, very helpful. And thank you. That's all I wanted to say.
Thank you. Any other comments? Okay, not hearing any or seeing any hands we'll move to remarks from planning commissioners. Okay. Let's go to Rick. Nothing? Okay. All right, Cortland.
I don't have anything else. Thank you.
All right. We will adjourn to the work session.
There we go.
Courtney, help yourself to some pizza. ordered a supreme for you without pepperoni. So you have to eat a piece.
Do you not like pepperoni?
I'm more of a sausage.
Yeah. Interesting, we all got different tastes.
Well,
June likes cheese and onion.
It's like the onion.
That's why we had to choose.
Anne ordered that. I did not order it.
Oh,
But I told her thank you anyway.
I've never had cheese and onion.
It's delicious, isn't it?
I think I mentioned this before, but Anne created this pizza at Domino's that's feta cheese and spinach with Alfredo sauce.
Mm.
I order that every time. And I didn't know that it was Anne's creation.
That's funny. I ordered that. It was on the thin crust.
Okay.
At, I can't remember where it was. It was up in Kiel.
Okay.
Yeah, and it was good.
It's still good. My wife thought the feta cheese was chicken chunks or something.
Yeah, because it's chunky.
Yeah, it's got a good texture to it, so. Anyway.
I want to go back and get one of those good cheesecakes we had at one time.
Should we get started though?
Yeah, so, thank you very much for coming to my work session. Last time, kind of,
part of the team.
yeah, right. This time it's mine. There were other items on for Charlie, but they're those ones that got pulled, so you get to listen to me this evening. Water conservation is something that's interesting, and I think it's topical. I just saw a article on KSL earlier today that was talking about how the 4 upper states that feed water into and use water out of the Flaming Gorge Reservoir decided just today or very recently that they're not going to release any more water out into the Lake Powell Green River system because they feel like they've got enough water to cover for this year. So they don't need to release any more water from Flaming Gorge. I thought that was interesting because water conservation is something that is cyclical, but it's also unpredictable. We run through cycles of times when we really need every drop of water, and then there's years like this year where we have over 100% of what we would get in a typical year. Some places in the state, I looked at the snowpack totals, some places are seeing over 200% of what they typically get in a year. So, but it's something that the state has taken a lot of interest in. As I mentioned last time we met, Senate Bill 110 from 2022, not this current legislative session, but the last one last year, added a new requirement that cities and counties add to their general plans an element that addresses certain things. And I just want to go over those really quick, what those are. They were in my memo, and some of you guys have had a chance to look at it, but I just wanted to highlight what some of these things are. They talk about looking at permitted development and patterns of development and what the impacts of those are on the water demand and water infrastructure. Looking at per capita consumption of future and existing development, and then providing opportunities for the county to modify the county's operations as a county internally to eliminate practices or conditions that waste water. Now, specifically in adopting a new general plan element, there are some specific things that the code anticipates that we will address, and they're laid out in pretty good detail. I'm not going to go over these line by line, but the idea is that we look at things like landscaping, reducing or limiting the use of lawn or turf, promotion of site-specific landscape design that decreases stormwater runoff, preservation and use of healthy trees, elimination or regulation of ponds, pools, and other features that produce unnecessary water evaporation, reduction of yard waste, efficient irrigation systems. Then it provides for recommendations for additional water demand, such as water budgets, adopting new or modified lot size configuration or landscape standards that reduce water demand. Yeah, there's a whole list of things that we need to look at as we go through the general plan. And my intention is that the next time we bring this in front of you, you'll have some language to look at that will respond to and modify the language that exists within the general plan, similar to what we did with the moderate income housing, and hopefully conform with and meet the requirements of this new statute and as outlined in Senate Bill 110. We had a little more time with that one. That's why we did the moderate income housing piece first, was because the Senate Bill 110 has a deadline of December 31st of 2025. So we've got a couple of years actually to look into this and make sure we get it right. But the idea is to create a plan that is workable, meaningful, and can achieve these goals as outlined in the statute.
Your objective is to put this in the plan, but not in actual code.
Correct. Now, there will be steps that can and should be reflected in the code when it comes to specific regulations that will help alleviate some of these concerns. And so we'll have a look at those and make those part of the general plan to help inform policy decisions and regulations in the future. But the state statute said, let's just put this in the general plan so that it's documented and that we can consider it as we go forward. If we have time, I definitely would like to look at this in ordinance as well. So we have this as part of our land use code, so that it's required and not just a policy in our general plan, because especially in the Ogden Valley, it's like we do not need formal landscapes and things like that. We need more natural scape and looking more at xeriscape and things like that. And I know the commission would like to see that as well. The people move up to the Ogden Valley specifically to look at the way things are naturally. And so putting in natural landscaping or landscaping that enhances the vegetation and things that are already there, it only makes sense. I think you're right on. The other thing that we'd like to have a conversation about is with the idea that water conservation is really a regional concern. It's something that as a county we ought to address, but it's also something that we ought to pull in other participants into the conversation as they work through their conservation efforts. It makes sense to talk to the municipalities that exist in the region to make sure that everyone is on the same page when it comes to water conservation. Part of that's going to be looking at informing how much water we have, addressing patterns of development and landscaping requirements, because it doesn't make sense for the county to adopt a particular, or the valley to adopt a particular standard or requirement or policy, and then all of the water then gets used by the golf course down in South Ogden, or farming out in West Weber that are using practices that are not water wise and not conservative or efficient. So we're going to be looking at this as not just meeting the requirements of the code, but from a more holistic and regional perspective to make sure that we're addressing these problems for future generations, really, to make sure we've got enough water for everybody.
So how specific, for example, in unincorporated Huntsville where I live, there are water companies or ditch companies. Some are open, some are pressurized. In theory, I guess the open ones waste a lot of water. And over the years that I've been there, they've moved to pressurized. Some have, some. We'll just go as far as to say these open ditches have to be pressurized. Like,
so that's part of the conversation we want to have. If there are things that we can do to work together with the ditch companies, with the irrigation companies to create a policy environment or a regulatory environment that is beneficial to both of us, both parties, both concerns and interests that we have, we want to have those conversations. I don't think and Rick, you can correct me if I'm wrong on this, but I don't think that the political environment right now is to like force companies to do things that they don't necessarily want to do, unless they're a bad actor or they're actively doing things that are wrong.
I think you're correct there.
What are the more than you work with Weaver Basin to like there's different grants that they can do as a design, right? And that's really probably the first line, right?
Absolutely, and that's one of the big, obviously, probably the biggest actor in all of this, the biggest partner that we'd want to make sure that we work together with, both in informing the policies and potentially even the regulations that we put into place, but also helping inform the conversation with the use numbers, the actual availability of water. All of those things are going to play a part of the conversation. So we want to make sure that we very broad strokes. And again, that would be part 2 of that conversation.
So you hit the nail on the head. People move to the valley because it's the valley.
Yeah.
They like the farmlands, they like the quaint shops, whatever. If this goes south and it doesn't get done right, it can change the valley.
Sure.
And what I mean is restrictions on agriculture, farming, ranches, stuff like that. You know, these guys, they live by their water. And they're gonna use their water every single time they get an opportunity, whether they need it or not.
Right.
I think incentivizing them, and I don't know how you do it. But some sort of an incentive to maybe not use your water if you don't need it then. I think we need to look at things like that versus saying, you can only use this many gallons of water a week.
So agriculture is an interesting one. There are quite a few exemptions and exceptions baked into the statute for agriculture. So when we look to create policies surrounding agriculture and regulations that would impose restrictions on agriculture, we're not going to do that without talking very closely and working very closely with the folks that are using that kind of water to make sure that what we're saying makes sense. If it doesn't make sense, we can't enforce it, first of all, because we're not the water police. We're not going to go in there and kick headgates down and fill ditches in. But if we can have a conversation that results in reasonable changes to the way people do things and help them find grants and other opportunities to help more efficiently use water, I don't think that there's any farmer or agricultural user of water anywhere that doesn't realize the importance of that water. That's their bread and butter. And if they don't have access to it, and if it dries up, we're all in trouble. So, and it's not just I can't shower, or I need to use the toilet, whatever. That's not. This is their livelihood. This is their family's income. So we need to make sure that we're doing things to help enhance and protect that aspect of it as well.
One thing I see for new projects going in is there's a big discouragement of, they want to keep open space, non-landscape areas. There's really no promoting agriculture.
Yeah.
From these bigger, when the parks are subdivided. I think it's a big mistake personally. The guy wants to go out there and he wants to have a hay field and he wants to have some horses out there. And he has to water that area in order to have those things. We basically strip that right when they buy that land. They don't get the opportunity to do that because the water's not available. Or there's too many restrictions.
So some of the questions I have is, first off, I don't know that we're the body to try and say what people will do with their water. These examples of agriculture, right? If I come in and I put my whole, if I have parcel, I put the whole front of it in rockscape, right, where there's no water in it. But Ogden City has their well behind me. How are we ever recharging the well? Right? Yeah. Well, we pipe the ditches are refilling the groundwater. And so what happens, how does that adversely affect several other people? So, I don't know that there's really a silver bullet to accomplish anything other than maybe encourage dry
dry season plants that don't need as much water. Yeah, I don't know what else, well, from a planning perspective, what can we realistically do? I mean, do we really want to talk, you know, where do we want to favor? If we got somebody who has a well, for example, Ogden City has a well in the farmer's field, and they're getting all the water, all the water that trickles down, you know, we're gonna say, well, we're gonna pipe that, we're gonna put houses all around it, we're gonna maybe put dry scaping, so only the water you get for your house, nothing else. Does that dry up the water for Ogden City, but it puts a little bit more in the irrigation for the people out west? You know, so I don't really know what to talk about, right? I mean,
Yeah,
what do we say?
in the general plan, it's gonna have guidance on who certain objectives are accomplished through. So say, for instance, if you're trying to do some type of enhanced ag protection, you're gonna be working, you're gonna say that will be geared towards maybe the Farm Bureau and Weaver Basin Water Conservancy District, working with them to accomplish those goals. It's not something we are gonna be as a fund mission, but we're gonna be accomplishing those things.
You're asking us to add it to the general plan.
Yeah,
So it's not even an ask, it's a requirement from state code. The planning commission create this amendment to the general plan and send it on to the county commission for review and approval.
So we'd say something like, we want to encourage farming and open irrigation, or as it stands.
yeah, it could be as simple as that. And it could also look at specific things too in there, because you know, if we start covering up our ditches, we start creating a problem, because in the springtime, those ditches help eliminate sheet flow. And so we've got to look at those issues as well. So there's a lot of complex issues that are involved here that, you know, we can't just, you know, narrow it down to one, because I like your idea of looking at a pressurized system. But if we cover up those ditches, then we got a huge issue.
They have
sheet flow.
so, but they keep the ditches open.
Yeah, my
Yeah.
preference, ditches all the way around and the pressure.
Yeah, and oftentimes when those ditches though aren't used, they get filled up with sediment over time, and then they're no longer good for sheet flow. Because they're not being maintained by the farmers and cleaned out, and so there are some issues that we have to, you know, look at when we start looking at, you know, and then that's where we have to bring in engineering into it and how we handle and deal with sheet flow.
So I do have a question though.
Yeah.
Speaking of the conservation, so you go up this Powder Mountain, right? Summit has no exterior landscaping at all up there, right? Then the design guidelines that it's required, but yet they have no water to be able to do it. So I'd say us as a county, as a body, we missed something there, because you need to reestablish grasses, right? Which create an erosion problem, because we didn't. It was so far to, not that there was a requirement there, but if we get the requirements there, there's no reestablishment, right? There was a miss there of a checkbox that they can actually reestablish, because now everybody up there, they can't put trees, or if they do it, they're doing it illegally, right? So I think that's the other end of the spectrum, is also making sure that we actually encourage regrowth when you cause development.
Yeah.
For revegetation and trees and for farming, of course, right? Let's take it to the residential. You have to make sure that it gets reestablished, right? Because up there, there's a problem with it not getting done.
And there have been certain projects up at Powder Mountain where we have said, you've got to do a reseeding, but you can only do it in the fall time, because, and you have to use a certain type of mesh requirement to hold certain hillsides in place, because it'll only take at those times of the year, because.
But it takes 5 years to grow back, and a winter like this, your seed might not take, because of how
Right.
the amount of water going off, right?
Yeah.
So I just think when you look at that, I think it really needs to be making sure that it's getting back to where it was on the disturbed properties too, right? That's my life, is disturbing dirt, right? So it's like.
So for us, I don't know that it's so much talking about conservation as much as it is about preservation of current, you know, because in the valley, it's more of a supply than it is a drop, meaning the snow flows down, it goes through, and then it comes down into the water systems. And so if we start saying, well, we're going to conserve, we're going to pipe everything,
what effect does that have? And where does the piping go becomes a problem, where if we're saying more like, look, we're gonna encourage like, low water usage of trees and whatnot that we can go put in and encourage natural landscapes to grow and regrowth, like you say, after development. Not so much, we want rockscapes and.
We gotta incentivize, right?
What's that?
Incentivize.
I don't know about incentivizing, I mean, I mean, realistically, what are we talking about, right? Like, so a developer comes in and wants to put in, 10 houses or whatever somewhere, and we just say, this is part of the code is that you put in, you regrow natural landscapes, or in Odyssey where we said, there's really, you can do 5,000 square feet max. And we're not a water company, we didn't even say that, right? That was the water company. And we said the rest of your acreage needs to remain natural. Yeah, which I think is a better way to go versus saying, hey, you got 10 acres, you need to make it into a rockscape.
Where I came from, prior to being here in Truckee, California, they have very strict rules in certain areas when you build a house.
You said that last week,
They-
in California, so.
They put a perimeter up. And you cannot step 1 foot over that perimeter during your construction. And that's intended to maintain the natural landscape, because it's there and here in my experience, it's really hard to reestablish it exactly as it was. I've tried for years to get my old pasture grass to look like new, or my new to look like my old. It's really hard. And when I built my house, tried to put that perimeter up, and I couldn't get the subs to stay within it. But if it was somehow there were teeth in that, then I think we would have a lot more of the natural landscape maintained.
For sure.
If it was required that when you submitted your plans, you also submitted footprint you were allowed to disrupt.
Let me just give you an example, a metaphor, maybe, if I could. I'm old enough to remember when light bulbs were glass tubes that were closed on the end and had a little filament inside, and those things were only 10% efficient. That means that the energy that went into it, only 10% of it came out as actual light. Then, I don't know, 20 years ago, they went to compact fluorescent lights, and they're great, but they also have mercury in them, but those are 30% efficient. Now we have LED lighting that's even more efficient than that. But I don't know what the exact numbers are, but 70, 80, 90% efficient on LEDs. Nobody came to me and said, we're going to force you to get rid of all your incandescent bulbs. If you've got them, continue to use them. But there's this new technology that's available that's more efficient. It's going to save you money. And no one, because they approached me that way, it made a lot more sense than if they beat me over the head and said, you're going to do this because it's saving whales and you're protecting the environment. And, I care about the whales too. Don't get me wrong. I want a good environment. I want a clean, healthy air. I like living and breathing. But I feel like it's the same thing with the water. If we can introduce the idea to people that reasonable steps can be taken to help both with a positive outcome when it comes to landscaping and how it looks, but also with the overall use of water and the impact on downstream and everything else. If we can introduce those ideas to people in a light that says, we're going to ask you to do these things voluntarily, think about them. Let's put in some measures that help people to understand education, all of those things. I think that we can get to a good place with this.
Go ahead. I think this is really complex. It's simple to say, let's pipe the ditches. But when the big irrigation company, I can't remember what it's called, Next Mumford's or President, they piped all their ditches. Great. It's over on Monst, all west of Monst. All kinds of stuff dried up.
Yeah.
Because this water is subbed out, and there's lots of trees along the ditches row, and it's all piping.
Yeah.
So there was a negative impact to that. Our irrigation comes from an open ditch, but I don't have to turn the water out. It just subs out of the ditch. And it goes out. If I pipe that, I put it in sprinklers, now I'm taking that water, it kind of subs and feeds the crop. And I'm putting it up there, now it's gonna evaporate. So that wasn't a winter. We did that. And all this water, all this irrigation stuff goes out and finds you. Anyway. And it overflows. You know, if it doesn't evaporate from the sprinklers, it's going out to find you. To benefit downstream. I saw an ordinance, Rick, I don't know how old it is. But maybe it was a proposed ordinance a few years ago. You can't plant anything in the valley that's not natural. Have you ever seen that?
There was a draft that never went anywhere.
Yeah. Well, what is nice about Huntsville? Why do we like going into Huntsville? The tree. Okay. If you read National Arbor Day Foundation literature, we talk about all the benefits from having trees. You lower the electricity used for air conditioning. You lower the heat coming off the parking lot because they're not shaded. So there's all kinds of benefits from having trees. So you gotta be careful when you say, oh, it's not, but people plant trees, they use water. Well, we made up for that because now we got all this extra electricity being used and all the extra radiation from everywhere that's not shaded. So if this could be looked at from a really big picture perspective, how do we, if it's conservation, it's conversation that comes serving valuable resources, but we don't want to save this one. You gotta really, there's no simple, oh, let's pipe it in. I mean, it's all respect, yeah. There's, whatever you do here is going to have an effect over here. What are the effects? And red sheet flow is something we're going to probably have this year.
For sure.
And yeah, the ditches pick that up and they get rid of it. And where they're all filled in, sheet flow is flowing into the window well.
And trees are a vital, important element to water conservation. Because if we end up having these large, parking lot areas, we have to have trees in those areas to reduce the heat island effect. So they're imperative. And to do all rockscapes, that's not smart because that requires more heat. Whereas if you use mulches and things like that, that's going to conserve water.
It's interesting with trees. There was an article, who was in Wall Street Journal or something, about trees. Or no, I don't know what it was. There was an article that talked about trees being a reducer of snowpack because they hold the snow up in the branches and then it melts and disappears or it evaporates quicker than coming to the ground and becoming ice, storing the usage. So some of the idea was reduce the number of trees and have more water. So I guess the question becomes, what do we really want to accomplish with
So there was one of the documents I sent or links to documents I sent, and I did they work at all? The ones I sent, did you?
I looked at it.
They were okay. There was a booklet that's put out. It's a fairly good sized booklet, 70 pages long of best practices and things that we can learn from and adapt to our situation here. From areas all over the West and with a focus on the Intermountain West and just little things that you can do to help address water conservation. So my goal is to try to glean some of that and present it to you guys in a way that makes sense and would fit well within the framework of our existing general plan. And again, hopefully meet the requirements of the Senate Bill 110. But then the larger conversation that we're having here about what it means to us and how do we interact with all the different players and how does it affect our daily lives? That's a real question. And that's where I think the real steps and progress can be made.
I mean, you guys are already doing some of this with your street sections, right? we should know from our studies, right? My master's was in urban planning and real estate development, right? So a lot of that is the cross section, how do you deal with putting it in storm drains actually not a great issue, right?
pushes
And
it
that's
out.
why you see we were just reviewing the street section, if you remember, talking about how wide it was, we needed that wide. You guys are already doing some of these things.
Yeah.
And I think Trevor just said, Chair just said something I think is important. We're not the experts here. But if we can hear from the experts, right, we shouldn't be the ones saying, how do we conserve water? Because we all have practice one way or another. I accidentally left my gun on for overnight last year, last summer when I shouldn't have, so that was bad on me, right? But the point is, like, we're all not, so how do we influence planning commissioners the right act? And I think that's a big ask.
Yeah.
So,
Well, we're here to help inform the conversation. That's part of the reason why we sent you those resources. Rick, Charlie, and I attended a workshop down in, where was it, Sandy?
Yeah.
At the Wheeler Farm last November, and we're all charged up. We're excited about all this idea, and we have contacts and people who are experts and would love to come and talk to you. We made new contacts with the Weaver Basin Conservancy District, and you know that there are a couple of planning commission members on the Western Weaver side that actually help run a water district out there, and so they're going to have ideas and valuable insights as well. So we've got access to the resources. We're going to get you the answers to the questions that you need so that we can make this a worthwhile process, and like I say, hopefully inform a much larger conversation about how we reach out regionally to pull in these things. Because it's, like I said, it's one thing for the Ogden Valley to say, well, we got plenty of water as we are. We don't need to worry about anybody else. Well, you do, because actually the water rights that go into the ground in the Ogden Valley translate out to the farms that are in West Weaver, and the drinking water, as you pointed out, that it goes into the wells for Ogden City. And we're all part of a system. We're all part of an integrated whole. And as such, we need to think that way.
So that, I guess that goes back to the question. So of what is going to be our goal? And I think that's the planning commission. So is the goal to put more water in Pineview and ship it down here? Or is the goal to kind of keep status quo? Right.
I think that's a good
Keep the
question.
ground as close to natural
Yeah.
as it would be if we weren't there, right? Which would be like, you know, being cognizant of the water as it comes off the buildings, it's stored and whatnot in the area, versus saying, okay, well, we really want to provide water down Wheeler Bay or wherever it goes.
Yeah.
And we just say, all right, let's pipe everything, don't use it right to the lake, and then it goes overflow in the river. My personal thoughts are to try and maintain a standard of what's there.
Yeah.
Right, of what would be there, and try and maintain that.
The hard thing is that the rest of our general plan says that we're going to experience growth, and we're going to put people in villages, and we're going to, you know, allow people to develop their property in a specific pattern. And so maintaining the status quo is at once very appealing, but it's also impractical long-term because of the growth patterns that we're expecting and hoping for, really.
So does that mean that we can't have those?
No, but this is the interesting thing, and Charlie and I were talking about this before, maybe it was a couple days ago, but let's say we do everything that we want to do with the valley, and all of the transferable development rights get pushed into the village centers, and we get density, we get lots of good dense apartments, condos, and smaller lots and things like that. Well, they all have water needs too. The water needs don't go away just because you've moved them from a greenland area and pushed it into a village center. But what's also interesting, and Charlie pointed this out, because this is in a conservation easement, the green space is in a conservation easement, an agricultural protection area, that's going to stay ag land forever. And that water use will continue, that water need and demand will continue while we've pushed all that development into this area, and that's gonna increase as well. So he's like, this is not a zero-sum game. This is something that we have to kind of game it a little bit more closely and watch and.
Like sewer, for example, we come and put sewer across the valley, that's gonna have adverse effects to the amount of water going.
Because of all the septics
Now
now.
it's only gonna be concentrated to wherever the sewer treatment plant
Yeah,
versus all over the valley getting water.
and make its way into Pine View eventually, yeah.
Well, if you flush your toilet now, the septic system is going in fine.
That's true. Yeah,
And then eventually it's coming down here.
The only water that comes out of your tap that's not going into Pine View gets evaporated.
yeah.
Kind of interesting, everything ends up in Pine. one way
Yeah.
or the other.
So we're gonna, at staff, we're gonna work together and put some ideas and thoughts in a more formal way and get that in front of you. Again, there's no immediate hurry on this. The due date is 2025. So we've got a little bit of time to work with this and make sure we get it right. And so more to come on this. That was really the point of this conversation, is to just introduce these two kind of different tracks that we're gonna follow and we're gonna get this going.
In some ways, the village plan is not consistent with, the general plan's village idea is not consistent with water conservation.
Right.
And that's.
Potentially,
You could
yeah.
talk about how, yeah, the farms might stay, but those big areas, I mean, the village funds are big areas.
Yeah.
That are now gonna be negative, sewer gets into that area, you're not gonna have that same amount of water going around. And especially if we put kind of a conservation plan. And just those, most of them are plans pretty dense, there's not a lot fully anyway.
Yeah. And that's where, a lot of the general plan concepts, you have to balance them out, because you're gonna be looking at creating the village core more dense, which is gonna require more water. But then if you do that, if you don't do that, then you're gonna have homes everywhere, and you're not gonna have the farmland. And so, that was a very important principle that the general plan talked about, is preserving those open space areas, which is gonna require more water.
The villages are actually, so if I take a, let's say, a farm, instead of being a farm, it's currently run. All we're getting is drinking water, which I bet that all of that irrigation water is way more than the drinking. It's going to be used and discharged through the sewer. So I would imagine that the question really becomes, is it about agricultural usage versus homes? And I think that's the separation we'll have to make is are we talking irrigation? Are we talking drinking water? Because my guess, I'm not a water expert, but the water that a home uses or a condo uses just for living space is very minimal. The water that a farm uses for, a 3-acre lot is a lot.
Right.
88%. I'm sorry, 98%, 2% of the water usage.
98.
It's in the 90%, at least it was when I did my master's,
Yeah.
right? It was, your highest is in agriculture. Now, when you use cities, you have secondary, right? So in essence, you could take all of that village, goes up, and then you use it as secondary. It's a whole system you have to put in. However, the farms could reuse, right? And it all comes back on.
So if you take a 5-member family, it's out on a 3-acre parcel, and you move them into an apartment in a village, the water usage for personal consumption, cooking, stuff, could be that same. But you got a lot less outdoor use, because these folks are all in apartment building, and you got a little thing by the walkway coming in the apartment, so so your landscaping use is going to be a whole lot less. But the open space is going to be farmland, that's going to use this secondary or
For the reuse, in this case, you can actually reuse that water because septic.
you can any sewer going in town. So I don't know that you lose a lot by having these villages. Maybe you know, but you probably don't lose a lot. I don't know if you gain any, but you may not lose as much as you think we are. We're gonna also be working with Utah State, and getting their perspective on this as well, because they've done some studies on this. So that's a resource that we have.
Thinking about that, we probably ought to think if we're gonna be looking at the village more closely. When we set so the idea currently is, well, people transfer it out. Well, economically, it doesn't make a whole lot of sense to have a 10-acre or 12-acre farm, can't make it work, right? So maybe we need to consider how we can better economically make that viable to keep, because I guess my point is there used to be tons of dairies and farms everywhere, right? Now there's it's not economically feasible to do that. And we're trying to keep that, and maybe we need to consider how to incentivize that as best we can. TDRs does help, but I don't know long term that will help. Yeah. You ever work it and we're all gone. Yeah, until the they're used up, and then it's like, well, now what? Now we just rezone everything. Yes. Increases. So in this overall state mandate, and so when I watched the video, I just was curious, and I looked up that from 20 to 21 population growth in the state of Utah was 1.68, and 21 to 22 it was 1.25%. 10th largest in the US. And then I looked at Weber County's estimated population rate of growth. 23 is 1.15%. So in this state mandate, are they saying, or are they perchance saying, well, here's this little pocket, Ogden Valley, maybe they shouldn't be allowed to grow at 7% or 8%. Maybe they should somehow be kept in line with state and county growth. Is that part of this equation?
It is part of it, but we live in a state that is encourages development, especially residential development. We like having places for people to come in and live and move from other places here, and we have larger than average families, and they all want to stay and need a place to live. And so there's these two pressures that we're dealing with. And the hope is that if we can put in good plans to help conserve water, that we will have the resource available for the foreseeable future. Every water person that I've heard speak or talk to has said that there is actually plenty of water available. If we would learn to use it more efficiently, and if we didn't just waste it.
How do you waste water?
Through inefficient practices.
And we saw that happen. We saw that happen in the fall time. We ended up cutting back on a lot of the landscape usage of water, and they attributed that to some of it not having such a big issue that they were expecting to have, and a lot of the state did it.
So we're talking about irrigation wasting.
That's probably one of the biggest issues that we have out there.
So I guess if you use drip system on your bushes rather than spray head,
that kind of thing,
there would be more water in Cobb in September.
But don't leave your gun on overnight.
That's what I was gonna say. If there was a way that he could get on Bluetooth and turn off his gun.
Yeah,
I mean,
water in the heat of the
It was
day.
that bad because he soaks the ground, and the ground.
Hey, my grass grew really good though.
Is it just evaporation that's wasting water? That's really the only culprit, right?
That and once a field is watered in like a flood irrigation, the tailwater gets picked up. It's often got fertilizers and other things in it. Then it can't turn around and be used very easily. It has to be cleaned before it can be put back in and things like that. So,
Couple of comments. If we want to go back to natural, let's go back to 1840. And what you probably, I wasn't there then, but you'd probably see close. You'd see steady growth around the river.
Yeah.
Middle Fork, South Fork.
Everywhere else would be sagebrush and rocks. That's what you'd see, that's natural.
Yeah.
You wouldn't see any Colorado spruce around Pineview or around Huntsville Park. You wouldn't see any of those.
In fact, I've got a friend that's a range specialist, and he says that the trees, the amount of tree coverage in our mountains and hillsides and things has increased by 70% in the last 100 years. We're seeing a lot more trees up in the hills.
The more trees have reduced the snowpack, reduced the water.
And it's not necessarily a good thing because it's conducive to wildfires and, it favors certain habitats and species that can utilize that, but to the exclusion of other animals and things that need the open air, the sunlight and things like that. So he's like, it's not actually a good thing. People look and think, oh, well, a tree, let's put our arms around it and hold on to it, but not necessarily a good thing all the time.
On the other side of that, my scoutmaster was one of the engineers that designed Pineview. We go on these hikes and everything was prevent erosion. You've got to have plants, you've got to have trees, or all this stuff's going to wash away. And then you got huge erosion problems, huge contamination of water. The other thing, if Charlie were here, I'm anticipating he would say, we had this discussion back and forth. It's not density, it's impact. And if you look at Wolf Creek area, you look up there where it's been there for a while, there are a bunch of trees and bushes and stuff. You don't notice it much. If you just see the brand new houses, whoa, we put that there.
Yeah.
So this vegetation does lower the impact of development, which is a good thing. So it's the big picture.
Yeah.
We gotta look.
I have an off-topic question. I'm almost done here. In these village areas, where's all the snow gonna go?
That's what we have to deal with, like up at Powder Mountain. And a lot of it has to do with, at the end of a cul-de-sac, we make sure that there's an empty lot there so it can be pushed in those areas. We make sure that if we have park strips, that, there's sufficient size that they can handle it. We have to look at those things.
And I would encourage that when we start looking at developments going in the north. For people to then have snow storage. And then that goes back to the second question. Snow melts, the water goes into a storm drain. Where does that water go? Does it go into a retention pond? Or does it just go out of the pipe?
Yeah, those are things that engineering they have to address.
Because on our, I don't know if you do this on your projects, some of the big ones, but we do a water retention basin or a storm tag.
Yeah.
All the water goes into the ground. And then if it overflows, then it goes out into the system.
It's a relatively new state requirement for low impact design. And making sure that the water is both retained as much as possible on site and makes its way into the ground from at existing levels. And then detention is added on top of that to help control flood drainage.
My understanding is of the villages, I don't see storm drains even on there. I think a lot of it's pervious surface, right? That we're trying to use. I mean, you're gonna eventually have to pipe if it gets too full, but.
You will. And I mean, they may have some oversized pipes underground to help accommodate that. They may do certain things with the park strips, with bioswells, different things like that to help accommodate for that. But they're gonna have to be more creative in the village areas, obviously, than in other areas to handle that, because they're not gonna be able to do the standard large detention area in those areas. They're gonna have to be creative to handle those types of things.
It's a tough one because technically they could just haul it out.
And I bet they will.
Yeah. And that's what some of the areas up at Powder Mountain are gonna have to do once they put the commercial component in, because the streets are required to be the buildings are required to be right up next to the streets, and so they will have to haul them out in certain areas. Just like Park City does.
Which that's an interesting question. I know that. So something to think about too, talking about water. So
Heber City's struggling to find places to put some. And not, like, they're hauling it, they got nowhere to put it.
So ultimately, when we use water system, they make the trailers, they use it at airports. Take this, the loader and you dump the snow in it, it melts it and just sends it in back into the water system. So the reuses.
From my understanding, they're having a hard time with that because of the water use. Treated.
No, it's reused.
The second is.
Secondary.
No, they won't let them dump, they won't let them melt, they won't let them. So for, it's Deer Creek or is that the reservoir? Whatever the reservoir is there.
Oh, Deer Creek.
They won't let them move it to the parking lot, like, Midway, they won't let them move it down there, but they want it all to stay right where it is. And so they're struggling to find places to put it, they can't melt it, they have to melt it in place and even then where you at, like where you put the water. Because in place, everything's frozen, so there's nowhere for the water to go.
Yeah.
So it's something to consider for sure, development stuff, because there's gotta be a place to put it.
Right.
Who wrote the best laid plans? I mean, it sounds easy to dump it in Pineview, tell the Forest Service says, I don't think so.
And turn it into another Salt Lake.
And there's some things that, as a planning commission, we can look at. Some of these things are out of our control.
Anyway, that's all I had for tonight.
So you guys remember when will the cost per year? Something like that, and that's all the pot, is the pumps, we got too much water. Now we're talking something.
Good one day.
He's gotta take the farmer's water and give it to people who can buy. But my neighbors and I were talking about this. And I said, these guys go with the motor. The sheet flow. All the water. Sample coming over the banks and all sandbagging in the morning. Oh, yeah.
They probably don't remember those light bulbs either.
Sandbag and the river. Yeah, so probably we're gonna get back. Sandbagging. And some people will dump water. Quite conservative.
Yeah, this might be low, steady melt.
Oh, yeah, because if you put this big village right in the middle of it. There's sheet flow all over you. Especially this year.
Basically, the snow stays on top.
I mean, one of the alarms, those kind of engineering stuff.
Oh, yeah. They do.
Yeah.
The big sheet flow we had in '80s.
Why the hell is sheet flow?
Ground.